So what is to come next in the Senzo Meyiwa murder trial? And also as we reflect on the past 3 years, we are joined by legal analyst Mr. Elton Hart. Thank you so much for joining us once again. We've been looking at this matter now for 3 years. And it's been quite a long time, in my perspective anyway. And I wonder what you make of, I suppose, the arguments that have been put forward by the state. Just as they rest their case, do you think they've put forward a strong position as the state over the past 3 years?
Looking at the evidence in totality that the state has put before court, right, there is for me a lot of question marks that I can raise against the evidence, that to say that for me it's not beyond reasonable doubt that these 5 men were the actual perpetrators of the crime of 26 October 2014. However, if you look at it from what the state has put before court, is that there is possible evidence or prima facie evidence that these accused need to come and answer to, as to why they were in the vicinity of the crime, based on the cell phone evidence, based on the photos, and also that gentleman, I think he was a police officer, the junior Zungu, not the father Absalom, the junior Zungu, that placed them in that vicinity. So there's circumstantial evidence, although I don't think it's strong, but there's evidence. And I think if they're going to bring an application in terms of 174, looking at the judge's behavior for the duration of the 2 years that he was on the case, Judge Ratha Mokgoatlheng, I don't think that they will succeed in getting that 174 discharge.
Yeah, but let's look at just the work of the state, right? And I want to focus on that. You say they've struggled to prove beyond reasonable doubt that the 5 that we're seeing in court could have committed the murder, but there's possible evidence that they were in the vicinity. Interesting. The witnesses that the state has called, though, have drawn quite a bit of attention over the years, with many saying, well, there are some voices that we would like to hear. What do you make of that?
No, obviously there is people that was in the house, like Kelly Kumalo, Longwe Twala, then also the neighbor, that lady that was in the house that was eventually found cleaning up the crime scene. For me, why did the state not call those witnesses? Because they were there in the house. They could also corroborate it if the story that Tumelo Madlala and Zandi Kumalo was giving us. Why was the other witnesses not called? Then it started raising eyebrows for me. Then also, if you look at the confessions and how the confessions was extracted out of the accused persons, and you could see that there it was always like the accused person is along with a lot of police officers. And what I could picture from the inspection in local, it shows to me that there is some possibility that these guys were tortured at some stage, and still the court said, no, these confessions were taken properly. So for me, there is a lot of things that cast doubt on the state's case. And for me, the law is clear. If there's doubt, then the benefit should be given to the accused persons. You must be out and out sure that this is the only inference that can be drawn from the evidence that's currently before court. And I don't think the only inference is that they killed Senzo Meyiwa that can be drawn from the evidence that's currently before court.
How do you answer the question that you're asking then, when you say, why did the state not call those that were in the house?
For me, it's either that these people will have conflicting information that might damage the state's case, and hence they did not call them. Maybe the state wants to actually use these 5 accused. Once they are found guilty, then maybe go after Kelly Kumalo and whoever else they might have in the pipeline. That can be a possibility, but I don't think that these 5 accused, if they are found guilty, they will go and implicate Kelly Kumalo if the state's narrative is to be believed that she paid them to actually kill Senzo Meyiwa. So for me, I think maybe that's one of the hands that the state wants to play, but obviously we will see as time goes by.
The options for the defense now moving forward? I mean, if you were in that courtroom as part of the defense, what were the steps that you would take now?
For me, I think one of the things that stood out for me is that maybe the ballistics experts, I don't think that these guys actually dealt with them decisively when they cross-examined them. Also, the guy that came to testify about the cell phones, and then also that Zungu guy that actually placed them in forced arrest. But if I'm the state, I'm going to first push my 174 application so that I see how the state responds to my 174 application. And if that is not successful, then I know exactly how to line up my witness sequence. So for me, I would call Absalom Zungu first, so that he can come and dispel that notion that the younger Zungu said that these guys actually killed, and so that he can actually bring the information that he shared in the interview, that how Brigadier Gininda approached him and wanted him to come and testify and implicate these guys, so that you cast sufficient doubt even on the credibility of Gininda's evidence that he brought by this old man saying that, and he has no reason to say this, and also he's gaining nothing out of it. Then I would bring the ballistic expert that they previously said they will call to come and also dispute the inferences that was drawn by the ballistics expert Mangena, that the state court, to say that that is not the only inference you can draw from what you find at the crime scene, and also looking at the bullets, the markings on the bullets, that came through the barrel of the gun, and also how that evidence was kept. So all those type of things.
And so I'm just trying to get back to some of the terminology here, because obviously not all of us understanding the jargon of what a discharge application, or what you call a 174 application, would actually mean, right? Just for the layman, for the everyday South African, what that application actually means.
An application in terms of Section 174 to be discharged, it means that you bringing an application to say that the evidence that's currently before court is not sufficient to actually warrant a conviction. And based on that, you don't need to answer to anything of that evidence, and then the court must just look at that evidence and say it's of such a poor nature that the court cannot, any reasonable court cannot find you guilty, and then you must be set free, which means it's like an acquittal. You are being cleared of the charges, and it's like when a court says not guilty. But this is now just before you as the defense or the accused actually present a case, because the evidence that was presented by state is so weak that you don't even feel there's a need to actually bring your evidence to come and rebut the evidence of the state's case.
Okay, so step one that the defense might then take is this 174 application. Let's assume that we throw the bones here. We say, right, that 174 or discharge application does then pass. What does that mean for the family that, 11 years on, still waits for justice? What's the next step that we would then see in their pursuit?
Now, obviously, the family can lay a complaint, or they can go and complain to the National Prosecuting Authority. The National Prosecuting Authority, being the people's lawyer, if one can put it that way, they can, if they're not happy with the outcome of the case, the judgment, to say if the court grants a 174 application discharging this accused, they can ask that the NPA then appeal the judgment. So they can appeal against this judgment to a full bench. If the full bench say, but Judge Ratha Mokgoatlheng was right in discharging these guys, they can go to the Supreme Court of Appeal and to the Constitutional Court eventually. So that is what the family can do in such a case. But obviously, if the highest court now says, okay, the judgment was correct, the discharge was correct, then that's the end of it. These guys are free, and the family never knows what really happened to their son on 26 October 2014.
Yeah, just two questions, and if I'm just piling them all into one, just in the interest of time here. The possibility is that now moving forward, as the defense takes over this trial, that we could see that second docket possibly rearing its head again. What do you see that looking like? And witnesses that you might expect the defense to call?
No, maybe the defense might dig into docket 375, but docket 375 is not currently the docket that's before court. It's 636 that's before court, and they have to deal with that because that's the case that's currently before court. However, they can call witnesses that made statements under 375, because that statement was made under oath, most of them. So they can call those witnesses, and those witnesses can come and testify on behalf of the defense in the case of or in defense of the accused. But I would want to see Epsilon Zungu, the old man, the young Zungu's father. He must come and testify. The ballistics expert must come and testify. I think they should actually bring a cell phone analyst to actually deal with the cell phone triangulation, to say that how these towers work and everything, because it cannot pinpoint where they were, because they were trying to place these guys at the hostel in Vosloorus, while these guys say they were at another spot, but in that cellular towers reach. So they need to bring somebody there, and then they need to also bring up the AVL logs of those vehicles as to where they stop, get a full record, and actually bring another person that can actually testify to say that there were stops where the accused say there were stops and they were tortured at their stops. Because I could pick up that some of the information are being dealt with selectively by the state, and not everything is placed on the table to say, court, here's all the information, and now you have to make a fair decision.
Yeah, and you wouldn't call for those that were in the house, like you said you would have expected the state to do?
No. Obviously, I don't know if they can call them, because now they can actually deal with them as hostile witnesses. Because I don't think those people in the house, because they know really what happened there, and maybe they might implicate each other. And I think they would not come and testify open and honestly. You can bring them, but then you have to declare them a hostile witness, in that they would not openly answer the questions. But I think that was for the state to actually bring these witnesses. The defense, I would think they would have a hard time, because these guys would not agree to come and testify in favor of the accused, because they want to also sort of uphold this narrative that these guys were the intruders and actually killed Senzo.
All right, very interesting. Elton, thank you so much as he continues to watch the Senzo Meyiwa trial with all of us.